5 gun law changes, already here or coming before the year is out, and the overwhelming majority of gun owners in America right now, in 2026, have no idea any of them happened, not one. The system that is supposed to inform you, the government agencies, the media outlets, the elected officials who pass these laws, none of them sent you a letter. None of them ran a primetime segment. None of them knocked on your door and said, "Hey, the rules just changed, and if you don't know about it, you could be facing a federal felony by Tuesday." That's not how it works. You are expected to know, you are legally presumed to know, and if you don't, the court that processes your case does not accept ignorance as a defense. These 5 changes, one already in effect since the end of last year, one that just took effect in February, one hitting Colorado in August, and 2 with national implications that every permit holder needs to understand, are the most consequential cluster of firearms law shifts we've seen at one time in recent memory, and almost nobody is talking about them with the urgency they deserve. If you own a firearm, carry concealed, or are planning to purchase any NFA item in 2026, subscribe right now and turn on notifications. Because what you're about to hear is the difference between staying legal and losing your rights permanently. And this is not an exaggeration. The first change is actually good news for most gun owners, but it comes wrapped in a trap that will catch unprepared people by the thousands, and the government is not going to warn you about it before it snaps shut. Effective January 1st, 2026, the $200 NFA tax stamp fee has been eliminated. This was part of a broader firearms reform package signed into law in the summer of 2025, and it affects suppressors, short-barreled rifles, short-barreled shotguns, and any other weapon classified under the National Firearms Act. $200 doesn't sound like a transformational barrier until you factor in that NFA items already carry significant purchase costs, that the approval process locks your money up for months at a time, and that for working-class gun owners, the fee represented a real threshold. It's gone now. If you've been sitting on the fence about a suppressor for home defense, because firing a weapon indoors without hearing protection in a genuine emergency is a real and serious risk to your hearing, that financial barrier no longer exists. If you've wanted a short-barreled rifle for vehicle carry or home defense purposes, and the stamp fee was the thing standing between you and the paperwork, January 1st removed it. But here is where the trap is. And it is a trap that will absolutely catch people who hear fee eliminated and hear rules relaxed, because those are not the same thing, and the distinction is the difference between legal ownership and 10 years in federal prison. The registration requirement has not changed. The ATF approval process has not changed. The background check, fingerprints, and passport photo submission have not changed. The processing timeline of 90 to 180 days has not changed. What changed is that you don't pay $200 to file the Form 4. Everything else remains exactly as it was, and the penalty for possessing an unregistered NFA item remains exactly as it was, up to 10 years in federal prison and a $250,000 fine. The ATF does not care that the fee was eliminated. They will prosecute unregistered NFA items as aggressively in 2026 as they ever have. And there is one more specific trap embedded in this change that you need to know about right now. If you submitted a Form 4 application with the $200 fee paid before January 1st, that money is not coming back. The ATF has explicitly stated it is not issuing refunds. If you had a pending application at the deadline, you paid a fee that no longer legally exists, and you are not getting it returned. Going forward, if you are planning to purchase a suppressor or SBR in 2026, the process is research your state laws first, because California, New York, New Jersey, Illinois, Massachusetts, Rhode Island, Delaware, and Hawaii still ban these items entirely, regardless of what federal law says. Then submit your Form 4 on or after January 1st without the fee, and then wait out the ATF processing timeline. That's it. Do not skip steps because the price changed. Now we move to a change that is not good news. It's a warning, and it already took effect. As of late 2025, the United States Sentencing Commission amended the federal sentencing guidelines for firearms offenses, and the penalties for straw purchases and false statements on ATF forms increased substantially. This is already law. This already applies to you. And the number of gun owners who are aware of it is disturbingly small. A straw purchase, to be absolutely clear about the definition, is when you use your own identity to purchase a firearm that you intend to give or sell to a specific third party who asked you to buy it or gave you money to buy it. Before these new guidelines, a federal straw purchase conviction carried a maximum of 5 years in federal prison. That maximum has now doubled to 10 years. And federal prosecutors are not treating this as a theoretical maximum. They are pursuing these cases aggressively because the enhanced penalties make them worth pursuing. The ATF prosecuted over 300 straw purchase cases in 2024, and that number is expected to climb through 2026 because the sentencing enhancement has made these cases a priority for federal prosecutors who now have real leverage in plea negotiations. Here is what makes this change even more dangerous than the headline number suggests. The ATF's investigative methods have grown substantially more sophisticated. They are cross-referencing Form 4473 submissions with financial records, tracking payments that correspond to firearm purchase prices, monitoring social media posts that document relationships between buyers and the people who end up with the firearms, and pulling surveillance footage from gun stores. They are also cross-referencing forms with medical marijuana registries in states where that data is accessible, with DUI records and with drug possession case histories. The marijuana question on Form 4473, Question 21E, which asks whether you are an unlawful user of any controlled substance, is the specific mechanism that is catching people who think their state's legal marijuana framework protects them. It does not. Federal law has not moved on marijuana. It remains a Schedule I controlled substance at the federal level, and if you use it, regardless of your state's position, and you check no on that question when purchasing a firearm, you have committed a federal felony. An Instagram post showing you smoking at a concert combined with a firearm purchase 2 weeks later is something federal investigators are actively using as evidence. They have stated this publicly. The cultural disconnect between state legal marijuana use and federal firearms law is generating prosecutions, and the new sentencing guidelines mean those prosecutions carry more prison time than they did 12 months ago. This is where I want you to stop and share this with someone you know who carries legally or is planning to buy a firearm in 2026. Not because it's content worth spreading, because it is information that protects people, and sharing it might literally keep someone out of federal prison. And if you haven't subscribed yet, do it now, because we still have 3 more changes to cover, and they get more personally consequential from here. The third change is a state-level shift, but it is one with national implications because it represents a template that other states are watching closely and may replicate. Colorado's Senate Bill 3, signed into law in 2025, takes effect on August 1, 2026, and it requires that anyone purchasing a semi-automatic firearm in the state of Colorado must first complete a state-approved firearms safety training course and obtain a permit before they can take physical possession of the weapon. To be precise about what this covers, semi-automatic pistols, semi-automatic rifles including AR platform rifles, and semi-automatic shotguns all fall under this requirement. The law does not ban any of these firearms. You can still purchase them. The transaction can still be completed, but you cannot take the gun home without the permit, and you cannot get the permit without the training. The training itself must be at least 4 hours long and must cover safe handling, storage requirements, Colorado-specific firearms laws, and a live fire qualification component. The cost runs between $75 and $150 depending on the provider, and Colorado is currently in the process of certifying approved instructors. That list is expected to be available through the Colorado Bureau of Investigation by June 1, 2026. Here is the critical detail for anyone planning a purchase in Colorado this year. If you already hold a valid Colorado concealed carry permit, you are exempt from this requirement. Your existing CCW satisfies the training mandate. If you do not have a CCW permit and you want to purchase a semi-automatic firearm after August 1st, you must complete the training before you can take possession, and these courses will fill up fast as the deadline approaches, particularly in July when every procrastinator in the state is scrambling for an available slot. The law also grandfathers existing owners. If you already own semi-automatic firearms in Colorado before August 1st, you are not required to obtain the permit retroactively. The requirement only applies to new purchases. But understand that the permit, once obtained, is not permanent. It is valid for 5 years and requires renewal through a refresher course. This is an ongoing compliance obligation, not a one-time hurdle. The consequences for non-compliance are concrete. Taking possession of a semi-automatic firearm without the required permit after August 1st is a Class 2 misdemeanor carrying up to 120 days in jail and a $750 fine. Critically, the gun dealer who transfers the firearm without verifying the permit faces the same penalty, which means dealers are going to enforce this requirement strictly because their own legal exposure depends on it. If you live in Colorado, do not wait until summer to look for an approved course. The list publishes in June. Demand will exceed supply almost immediately. The fourth change is the one that should concern every gun owner who lives in Kentucky, has family in Kentucky, or is paying attention to the direction that state-level firearms legislation is trending nationally. Because what Kentucky just implemented is one of the most expansive red flag law frameworks in the country, and it took effect on February 1st, 2026. Kentucky is now the 22nd state to enact an extreme risk protection order law, and the version they passed is notably broad in both who can file and what the consequences are. An RPO allows a court to order someone to surrender all firearms and suspends their concealed carry permit based on a petition that they pose a danger to themselves or others. The list of people who can file an ERPO against you in Kentucky is long, current or former spouses, anyone who has lived with you within the past year, family members by blood or marriage, anyone you have been in a dating relationship with within the past year, and any law enforcement officer. That is an expansive list of potential petitioners. The standard of proof for an emergency ERPO is reasonable cause to believe, which is one of the lowest evidentiary standards in American law. What this means practically is that someone on that list of eligible petitioners can go to a court, make the argument that you pose a danger, and a judge can issue an emergency order requiring you to surrender every firearm you own within 24 hours and immediately suspending your carry permit. You receive no advance notice. You are not present at the initial hearing. You have no opportunity to respond before the order is issued. The first indication you may have that an ERPO exists against you is when law enforcement arrives at your door to collect your firearms. At that point, you have 24 hours to comply. You are not given more time because you weren't warned. You are not given an extension because you have nowhere to store the firearms. 24 hours. And the 14-day due process hearing, which is your opportunity to present evidence and challenge the order, comes after you have already been disarmed and after your carry permit has already been suspended. During those 14 days, you have no legal access to your firearms. If the court makes the order permanent at the hearing, it can last up to 1 year and can be renewed if the petitioner files again. The penalty for possessing a firearm while an RPO is in effect is a Class D felony in Kentucky, 1 to 5 years in prison. Even after an RPO expires, your firearms are not automatically returned. You must petition the court for their return. If you live in Kentucky and you are currently in a divorce, a custody dispute, or any situation involving conflict with someone on that eligible petitioner list, document everything right now. Keep records of all communications. Note witnesses to any interactions. Because once an ERPO is filed, you are on defense with a 14-day clock. If an ERPO is ever filed against you, retain a firearms or civil rights attorney immediately. This is not a situation where self-representation is an acceptable risk. The fifth change is different from the previous four because it is not yet law, but it is closer to becoming law than it has been at any point in the past decade, and understanding it now is essential both for what it would mean and for the warning that comes with misunderstanding its current status. H.R. 38, the Constitutional Concealed Carry Reciprocity Act, was reintroduced in the House in January 2025 with 213 co-sponsors, nearly half the House, and is currently moving through the legislative process in 2026. If it passes and is signed into law, it would mandate that every state in the country recognize a valid concealed carry permit issued by any other state. The implications of that single change are enormous. Right now, the concealed carry reciprocity map is a patchwork that defies rational navigation. Texas recognizes permits from 42 states. California recognizes permits from 0 states outside its own. New Jersey recognizes none. New York recognizes almost none. A gun owner with a Texas permit who drives through New Jersey is committing a felony. Not because they are dangerous, not because their permit isn't valid, not because they failed any test or background check, but because they crossed a line on a map. H.R. 38 would make your carry permit function like your driver's license, valid everywhere, not subject to additional state requirements, not contingent on the political preferences of whatever state you're passing through. Your home state permit would be your permit, period, in all 50 states. The bill passed the House in 2017 before dying in the Senate. It has returned with stronger support and a different political environment. But here is the warning that cannot be stated emphatically enough. This is not law yet. It is in committee. It has not been voted on in either chamber in this session. Even if it passes the House, the Senate remains the uncertain variable. Even if it passes both chambers and is signed, multiple states would immediately challenge it in court, creating an enforcement landscape that would be genuinely confusing for months or years during litigation. Until you see a presidential signature, followed by the law surviving its initial legal challenges, you must continue operating under current reciprocity agreements. If you travel frequently across state lines with a concealed firearm, the practical answer right now in 2026 is non-resident permits from high reciprocity states. Florida, Utah, and Arizona are the 3 that cover the most ground. Carry reciprocity maps must be checked before every interstate trip because they change, and because the difference between legal carry and a felony charge is sometimes a single state line 20 miles from where you live. Here is what all 5 of these changes demand from you, taken together, and this is the part where I want you to sit with the real systemic failure at the center of all of this. The federal government, across its regulatory agencies and legislative bodies, generates an enormous volume of firearms law changes, amendments to sentencing guidelines, fee structure modifications, new state laws enabled or influenced by federal frameworks, pending legislation with major implications. None of this is communicated directly to gun owners. There is no notification system. There is no annual summary sent to the 45 million households in America that contain firearms. There is no proactive outreach from the ATF explaining that the penalties for something you might accidentally do just doubled. You are legally responsible for knowing all of it, and the mechanism for learning it is entirely on you. That is a systemic failure that deserves to be named clearly because it generates prosecutions of people who genuinely did not know the rules changed, and it generates those prosecutions disproportionately among people who cannot afford the legal representation to fight back effectively. The action plan for right now, in February 2026, is this. If you are planning any NFA purchase, suppressor, SBR, SBS, begin the process now without the $200 fee, and do not skip registration under any circumstances. If you use marijuana in any form, understand that federal law has not changed, and Form 4473 is a federal form. Answer it based on federal law, not your state's position. If you live in Colorado and do not have a CCW permit, find an approved training course before August 1st and get registered early because those slots will not be available in July. If you live in Kentucky or have close relationships with people who could file an ERPO under the new law, document your interactions and know the name of a firearms attorney before you ever need one. And on H.R. 38, track it, understand what it would mean, but do not act as though it is already in effect, because it is not. Comment below with your state and which of these 5 changes affects you most directly. Tell me what you're seeing on the ground. Tell me what other changes are coming in your state that deserve this level of attention. And subscribe with notifications on, because gun law in America in 2026 is moving faster than it has moved in decades, and the cost of missing a change is not inconvenience. It is your freedom, your rights, and in some cases, your future. You deserve to know what the rules are. This is me making sure you do.